we're all being our best behaviour. In respect of COVID prevention, just to note we have masks and hand sanitizer available should anyone wish to avail of them. Please, social media experts, use your skills, and we'd encourage absolutely everybody at the event using the hashtag AHRL2022 and tagging the Commission at NIHRC. That's hashtag AHRL2022 and tag at NIHRC. And the proceedings for those who are here. Compliments of Bar for NI. Right, let's get down to business. I'm very delighted to welcome the Right Honourable Dame Siobhan Keegan, Lady Chief Justice of Northern Ireland, who will give an opening address to us. Dame Siobhan is very well known to the audience today and an inspiration to so many people wishing to pursue a career in law. Siobhan has been the presiding coroner, a High Court judge since 2015, designated judicial member of the International Hague Network of Judges. She was a commissioner in the Northern Ireland Judicial Appointments Commission, of which she is now chair, an honorary member of the Society of Legal Scholars, and 2nd of September 2021, she broke new ground for all of us in being sworn in as Lady Chief Justice. A very warm welcome, Siobhan. Interested to hear your address. Thank you.
Well, thank you very much for that kind introduction. Immense pleasure to be opening this, the Northern Ireland Human Rights Commission lecture. I also would like to extend my own welcome to Lady Hale, who is a very dear friend of our jurisdiction. She was in this very room when the Supreme Court came to Belfast. She has recently been made an honorary bencher of the Inn of Court of Northern Ireland and receive an honorary doctorate from Queen's University Belfast tomorrow. Now, she has very, very many other accomplishments which I will cite, but Lady, you are very welcome. I'm so very much looking forward to hearing what Lady Hale has to say on her chosen theme. Should there be a British Bill of Rights? It is most certainly a issue, given that the Bill of Rights is currently making its way through the various parliamentary stages. I'm going to speak to you briefly this afternoon, not about Bill of Rights questions, but rather about a few Northern Ireland cases where human rights issues have been engaged most recently. Before I do that, I think the context of current discussion on human rights. The European Convention on the Protection of Human Rights and Fundamental Freedoms, the treaty, which, as you know, was signed on the 4th of November 1959 by governments who were then members of the Europe. The Council of Europe, of course, as well, established in 1949 as part of the Allies' programme to reconstruct durable civilization on the mainland of Europe. The United Kingdom ratified the convention in 1951, but other signatories, it did not become part of domestic law until the Human Rights Act in 1998. Prior to that, from 1966, the United Kingdom granted the right of individual petition to the Europe of Human Rights. There are always issues in this area. However, we are now familiar with the need for protection of fundamental rights in our law, such as the right to life, liberty, family, privacy, freedom of expression, and also prohibition on matters such as slavery, torture, and discrimination. The Human Rights Act, by its nature, allowed the courts to give effect to convention rights in primary and secondary education by reading down in accordance with Section 3, and in appropriate circumstances by making a declaration of incompatibility incompatibility under Section 4. In circumstances, it's for Parliament to change the law. In Chapter 7 of Tombold, the rule of law, the fifth of his core principles is that the rule of law must afford adequate protection in fundamental human rights. In the text, he refers to what he calls a thick definition of the rule of law, embracing the protection of human rights within its scope. He also said this: "It must be accepted that the outer edges of some fundamental rights are not clear, but within a given society, there is only a large measure of agreement on where the lines are drawn at any particular time, even though standards change over time, and in the last resort." The specific Northern Ireland perspective is framed by the Belfast Agreement, reached in 1998. Anti-discrimination and equality legislation to be introduced. Ordinance arrangements in Northern Ireland would include human rights protections based on the European Convention on Human Rights. A Human Rights Commission was established with, among others, of developing proposals in Ireland Bill of the European Convention on Human Rights. And also the North-South dimension provided that human rights protected in Ireland, including socio-economic rights such as labour and employment rights, would to be equivalent to those in Northern Ireland. It was also provided that Ireland would incorporate the European Convention on Human Rights into Irish law, that there would be a joint committee of the Northern Ireland and Irish Human Rights Commission, and that an All-Ireland Charter of Rights would be produced. 1998, which settled devolution arrangements in Northern Ireland post the Belfast Agreement, specifically recognises convention rights in Section 6 of competence. In addition, as we know, the Northern Ireland Human Rights under Part 7 of this statute. Of course, difficult questions arise post-Brexit, but they are for another day. In the remaining time I have, I propose to highlight a couple of areas which illustrate what I call the development of a rights-based jurisprudence in Northern Ireland post the Belfast Agreement. In doing so, the obvious point to make is that this jurisprudence has spanned many aspects of life here and been employed by many different sections of our society. I'll briefly mention a few areas of current interest. First, the cases that arose during the COVID-19 pandemic. Interestingly, the questions before the court did not touch so much on the lessons put forth in public health emergency, but in relation to the proportionality of the interference, in particular to family, invoking Article 8 of the Convention. By way of illustration, in the summer of 2020, at the height of the pandemic, the case of a mother was heard in the Family Division. This was an application brought under the Human Rights Act to challenge upon physical contact between a mother who had been separated at birth by way of care order. The fact of the baby being removed from the mother's care was not contentious. The issue in the case was the contact difficulties in having what was called skin-to-skin contact. The court took a pragmatic approach in this case, which I think is bespoke to the jurisdiction that we have. The Chief Medical Officer was contacted and provided correspondence noting potential longer-term adverse impacts on mother and baby if direct skin contact did not take months of a child's life. It was that the requirements and recommendations for of direct skin contact at that point in time had become unnecessary and disproportionate. And this ultimately led to a change in the health trust policy and the direct skin-to-skin contact taking place. Another area in which our rights-based jurisprudence through litigation in our jurisdiction concerns matters of social policy. We saw this in Northern Ireland, same-sex marriage, which pertained until relatively recently. And Sickles, in a judgment delivered in 2020, the Northern Ireland Court dealt with an appeal from a dismissal by the High Court of a claim the prohibition on same-sex marriage in the Marriage Northern Ireland Order 2003 unlawfully discriminated against the on the basis of sexual orientation, contrary to Section 6 of the Human Rights Act and Article 14 of the Convention. The Court of Appeal considered that at this being issued, having regard to a range of issues, the prudence, a fair balance struck between the rights of the appellants and the interests of the community in marriage. In the first instance judgment had been delivered in August 2017, however, the Court of Appeal considered that the absence of same-sex marriage in Northern Ireland did discriminate against same-sex couples, that a fair balance between traditional and personal rights had not been struck, and therefore that the discrimination was not justified. In the event provision for same-sex marriage having been made in this jurisdiction in 2018, it remained no declaration under Section 4 of the Human Rights Act was necessary. And this was where the law also changed in line with the Supreme Court decision in the Northern Ireland Human Rights Commission case in relation to abortion. These provide an interesting illustration of how the landscape in relation to rights that may be of relevance to a court in balancing rights and interests can even for a relatively short period of time, and indeed as in this is during the course of proceedings. Moving to Article 10 and freedom of expression relative to public order, the Court of Appeal determined a case stated in Brown versus Public Prosecution Service. This involved consideration of a legal question as to whether the appellant's conviction for an offence under the Public Order Order of 1987 in Northern Ireland was lawful. The appellant had been convicted as a result of distributing leaflets in the local area complaining of an influx of Roma into the community and making adverse comments about the entire context of rallies were taking place in the area. Of course, the conviction could only be lawful if all of the ingredients of the offence were established and the conviction was compatible with the right to freedom of expression contained in Article 10 of the Convention. This question required consideration as to whether the facts of the case constituted hate speech, which can be punished by within the meaning of the law of the European Court of Human Rights. The term hate speech, of course, does not appear in the public order legislation under which the appellant was convicted. However, the term is understood to mean any communication in speech, right behaviour that attacks or uses pejorative or discriminatory language against a group. The fact that the expression in question involved hate speech and is intended or likely to stir up hatred or fear does not in principle preclude it falling within the scope of Article 10. Whether the speech is protected by the Convention will depend on the specific facts and context of the case. In this case, our Court of Appeal found that the conviction did not comply with Article 10, as the relevant factors had not been balanced in reaching a decision, including in particular whether there was any protection to be afforded by the nature of this speech and whether it came within the umbrella of political speech. Also, crucially, applying Convention jurisprudence, proper reasons were not given to justify the interference with the Convention right, so the case was remitted for rehearing. The legacy of Northern Ireland's past also continues to engage our courts, particularly as regards whether the Article 2 investigative obligation is complied with in a particular case. This is subject to ongoing challenge before the courts and is an area which will continue to involve rights-based. I'll mention one final case in which the Northern Ireland courts have recently made a declaration of incompatibility. That is a criminal case involving Morgan and others. It involved a claim that recent counter-terrorism legislation was in breach of the Human Rights Act, in particular Articles 7, 6 and 5. In short, it asserted that the legal basis of the new regime was incompatible with the Convention by retrospectively applying a longer sentence. In this, the court decided that Article 7 infringed by the nature of the new legislation and made a declaration of incompatibility. This is an important case which is now to be heard in the Supreme Court. You will see from what I've said in this brief snapshot that there are many and various areas in which arguments have been made. My final comments are forward-looking and the potential future direction of Northern Ireland's rights-based jurisprudence. I've spoken about recently in a lecture looking ahead to the next 100 years of law in Northern Ireland. And I said in particular two things. Firstly, I see in the future that the effects that flow from our digital age and changing modes of expression will fuel our law. As our use of the internet as a society has developed, difficulties in regulating expression have arisen, and the consequent challenge of proper regulation. Judge Siofra O'Leary, Vice President of the European Court of Human Rights, in delivering the Summit lecture, highlighted this theme. She talked about the emerging concerns about the spread of misinformation in a democratic society. And she said this: the court has sought to grapple with the conflicting realities to which the internet and new technologies give rise. It has recognised on the one hand that user-generated expressive activity on the internet provides an unprecedented platform for the exercise of expression. On the other hand, the internet can act as a forum for the speedy dissemination of unlawful forms of speech which may remain online. The second area I've raised is what I recently heard described at a conference as the rising tide of climate change around the world. Backdrop of the Paris Agreement 2015 and the Climate Change Act 2008, which sets a mandatory target for carbon reduction, we are beginning to see what will become a substantial body of law generated in the area of climate justice. There is already a growing jurisprudence in the United Kingdom. These cases are not only strategic, challenging government action and non-adherence with international targets, but also individuals are bringing challenges, some of them children, invoking convention rights, in particular Article 8 and Article 2. The issues highlighted by my inevitably short and snapshot survey of Northern Ireland's rights-based jurisprudence, I hope gives you some flavour of the variety of ways in which rights issues are engaged day and daily in the Northern Ireland courts, and most importantly, in the daily lives of those who live here. There can be no doubt that rights are deeply embedded in our legal landscape. Undoubtedly, Lady Hale's lecture this evening will illuminate further on where we are and where we are going. Thank you very much.
Could I thank Our Lady Justice for setting the scene so well and for a very poignant reminder of the way that human rights issues touch the lives of the people in our society so broadly and so deeply. I'd like now to introduce our keynote speaker, and I will give her full formal title, the Right Honourable the Baroness Hale of Richmond, DBE, with her talk on Do We Really Need?
Embedded in our legal landscape. Undoubtedly, Lady Hale's lecture this evening will illuminate further on where we are and where we are going. Thank you very much.
Could I thank Our Lady for setting the scene so well and for a very poignant reminder of the way that human rights issues touch the lives of the people in our society so broadly and so deeply. I'd like to introduce our keynote speaker. I will give her full formal title, the Right Honourable the Baroness Hale of Richmond, DBE, with her talk on Do We Really British Bill of Rights. Lady Hale retired as President of the Supreme Court of the United Kingdom, the most senior judge in the UK, in January 2020. Before becoming judge, she had a varied career, including as an academic lawyer at the University of Manchester, and as the first and youngest woman member of the Law Commission. She was appointed a High Court judge in 1994, and in 2004 became the first and only woman Law Lord of the House of Lords. She subsequently became Deputy President of the Supreme Court in 2013 and its first woman President in 2017. Lady Hale has been described as a pioneer, a trailblazer, an agent of change and a superhero with superhuman strength, incredible stamina and a resistance to the toxin of sexism. She is also described as having patience, which is my signal to stop gabbling and let our keynote speaker speak. You're very welcome, Lady Hale.
Well, thank you very much indeed for the invitation and for the introduction. It is great to be back in Northern Ireland and specifically in this room where I well remember the visit of the UK Supreme Court, which sat in this room. It's much nicer to be here giving a lecture than it is to be here listening to counsel. You're going to have to listen to me, I'm afraid. Sorry about that, but I've got quite a lot to say. The title that I proposed was Do We Need a British Bill of Rights? I suggested this title after the government had its consultation paper on a British Bill of Rights before the bill was introduced to Parliament on the 22nd of June. This has not left me with very much time, let alone with the government's report on the response to its consultation paper or the explanatory notes to the bill. Please forgive me if my comments are not as polished as they ought to be. In other words, don't believe a word I say. Of course, when I suggested this title, the answer was easy. Like many other well-informed, including Sir Peter Gross, who chaired the Independent Human Rights Act review, it was a resounding no. As that review found, there is very little wrong with the Human Rights Act, and what little there is wrong could easily be put right by amendment. Repeal and replacement with an act which does much the same thing, in much the same way, but with some important qualifications and is full of dangers. Quite from reducing the protection currently available to the victims of human rights violations, and thus risking the breach of our international obligations, it will lead to doubt and uncertainties and a greatly increased risk of time-consuming and costly litigation, both here and in Strasbourg, for years. And the case for taking that risk not been made out. It was, of course, reassuring that the government consultation paper announced that the UK would remain a European Convention on Human Rights. This means, of course, that it has to provide an effective remedy before a national authority for every rights and freedoms as set forth in the Convention are violated. That's Article 13. And it also has to accept of any person, non-governmental organisation or group of individuals claiming to be the victim of a violation of the Convention rights to petition the European Court of Human Rights. It must abide by the final judgment of the court in any case to which it is a party. One of the many concerns voiced by commentators is that decision-making within the United Kingdom from decision-making in Strasbourg will result in fewer victims gaining redress in the UK courts, more having to go to Strasbourg, and more adverse decisions against the UK in Strasbourg. And so the reverse of the Human Rights Act declared object of bringing rights home. There is also a concern that the bill, combined with other proposed legislation, may put the UK in breach of its international obligations under the Convention. But the government doesn't think so. Secretary Raab stated that in his view the provisions in the bill are compatible with the Convention rights. Well, I wonder. The first thing to notice about the bill is that rather than begin by mapping out the basic scheme for converting the Convention rights into rights in UK law, the Human Rights Act does, it begins by sloganising and putting up front all its most eye-catching proposals, designed to appeal to including the media, who have long been opposed to the Human Rights Act. So, for example, Clause 1, 2a provides that it is the Supreme Court, and not the European Court of Human Rights, that determines the meaning and effect of Convention rights for the purpose of domestic law. See also section 3.1. But this has always been the case. The Supreme Court, and indeed any court which decides a case concerning the Convention rights, including the Northern Ireland Court of Appeal, already determines the meaning and effect in domestic law. If the case goes to Strasbourg, it's not an appeal from the decision of the domestic court. That decision still stands. The applicant brings a complaint that the UK, as a state, has violated the Convention rights. Any adverse judgment is against the UK as a state, which must then abide by the Strasbourg Court's judgment. But the interpretation arrived at by the UK court is still binding on the lower courts, unless and until the higher court decides to change it in response to what Strasbourg has said. There is absolutely no need for this grandstanding provision, or for the equally obvious statement in Clause 1.3 that judgments, decisions and measures of the European Court of Human Rights are not part of domestic law. Neither, of course, do they affect the right of Parliament to legislate. So far, scary, but probably harmless. Perhaps also comparatively harmless is the repeal of Section 2 of the Human Rights Act, which requires the UK courts to take into account the jurisprudence of the European Court of Human Rights, the Commission and the Council of Ministers when determining questions about the Convention rights. We were never required slavishly to follow it, but we mostly took the view that, coupled with the Act's purpose of bringing rights home, it meant that if it was clear that the claimant would win in Strasbourg, then the claimant should win here. But even then, we could decline to adopt the Strasbourg line if it was contrary to some fundamental principle of UK law or ignored some important point of UK law or practice. In such cases, we enter into a constructive dialogue with Strasbourg. Strasbourg usually modified its position in response. The bill does not repeat or modify Section 2, but neither does it expressly forbid the UK courts to take the Strasbourg jurisprudence into account. Well, that's a relief. So, they are left without guidance as to the weight to be given to it. But they are told that they can adopt an interpretation which is different, as long as they don't take it further than Strasbourg would do, thus decoupling the two. Is the repeal of Section 3 of the Human Rights Act. There will no longer be an obligation to read and give effect to legislation in a way which is compatible with the Convention rights. It seems to have been forgotten that Section applies to everyone, not just to courts. Everyone has to read and, just as importantly, give effect to legislation in a way which is compatible with Convention rights, if it's possible to do so. Both the Joint Committee on Human Rights and the Independent Human Rights Act Review noted had a beneficial effect which went way beyond what the courts do in expecting everyone to respect the Convention. For example, there's been an impact upon practices in care homes which had previously, without thinking about it, violated residents' privacy or subjected them to inhuman or degrading treatment. The consultation paper complained that Section 3 allowed courts to amend legislation. But the principal example given was Gaidan and Mendoza. The House of Lords interpreted living with a deceased tenant as his or her wife or husband to include same-sex couples. Yet I would be very surprised if most people would now read it in any other way. And they fail to point out that the government itself intervened in the case to argue strongly for this interpretation. Indeed, it has been common for the government to argue, first, that a provision is compatible, but second, that if it is incompatible, then Section 3 could cure the problem. In other words, for the courts to let them off the hook of having to decide. This tendency was whatever the political stamp of the government in power. With Section 3 gone, the courts will be told to have particular regard to the text of the convention right, and that they may have regard to the preparatory work of the convention in interpretation. This is clause 3.2a. This looks like a strong nudge towards what in the United States would be termed originalism, what the original drafters meant, or what its original readers thought they meant, and away from the living instrument doctrine which has led to Strasbourg developing the convention to meet new problems and changing social conditions. There are, of course, those who think that the living instrument doctrine has been taken too far, but we shouldn't forget its beneficial effects. For example, in securing equal rights for children born to unmarried parents, the right of access to a court to determine civil rights and obligations, or the right to an effective inquiry into deaths for which the state may bear responsibility, all of which have been the result of the living instrument doctrine. More significantly, courts will also be told that they may not adopt an interpretation of a right which expands the protection given by the right unless the court has no reasonable doubt that the European Court of Rights would adopt that interpretation if the case were before it. So what would happen to a case like Rabone, where the UK Supreme Court decided that an institution's duty to protect your life, which was known to be at serious risk, extended not only to prison. The Strasbourg Court reached the same conclusion as the UK Supreme Court had reached only a few weeks later. It had no reasonable doubt that it would, but it goes further than that. What about cases where we can be pretty confident of the direction of travel in Strasbourg, but it has not got there yet, content to allow member states to decide matters for themselves, affording them what's known as a margin of appreciation? We had understood from ministerial statements in both houses of Parliament before the Human Rights Act that they expected the courts to develop convention rights in a distinctively British way. bearing in mind the long tradition of protecting individual liberty in UK law. Many commentators were critical of the no more part of Lord Bingham's famous dictum in Uller, that we should keep pace with the Strasbourg jurisprudence as it develops over time, quote, no more, but certainly no less, end quote. So in Re G, the House of Lords decided that the Northern Ireland order preventing unmarried couples from adopting was unjustifiable discrimination in the enjoyment of their right to respect for their private and family lives. Strasbourg did get there in the end, but at the time it would still have been within the margin of appreciation. The same can be said of the majority decision of the Supreme Court in the Northern Ireland abortion case brought by the Northern Ireland Human Rights Commission. So we had got into the habit of, in appropriate cases, developing the law where the margin of appreciation left it to the national authorities. However, in the Elan Kane case, the Supreme Court of the United Kingdom has recently done the government's job for them, holding that if a case is clearly within the margin of appreciation, so that Strasbourg would not find a violation, the courts cannot do so. Parliament is to be the sole judge of what to do about matters which fall within the UK's margin of appreciation. I confess that I did say something to that effect in an early Human Rights Act case, but was convinced otherwise by lesser figures and very disparate figures than Lord Hoffman and Lord Hope, Re G. Of course, there are areas where the courts should respect the greater institutional competence of the government and Parliament, but the courts have traditionally regarded themselves as competent to rule on matters concerning the liberty of the subject and indeed on discrimination, at least in certain areas. There is a particular need for the courts to protect minorities against discrimination by the majority. The bill, puzzlingly, tells the courts that they may have regard to the development under the common law of any right which is similar to the Convention right. But what is the point of that if the common law has developed the right further Strasbourg has done, but the UK court is not allowed to do so? Don't know what that provision is there for at all. Tellingly, there is one exception to the prohibition on expanding the Convention rights, and that is freedom of speech. Clause 4.1 tells the courts to give great weight to the importance of protecting the right to freedom of speech, and they are allowed to expand that right further than Strasbourg has so far done. It's not clear to me whether and to what extent this is meant to mean that freedom of expression trumps the right to respect for private and family life. We can expect some lively arguments about that. But any attempt to argue that Clause 4.1 is itself incompatible with the Convention rights would come up against Clause 7. This says that when deciding incompatibility questions, where it's necessary to decide whether a provision in an Act of Parliament strikes an appropriate balance between, among other things, different Convention rights, the courts must regard Parliament as having decided that it did strike an appropriate balance and give the greatest weight possible to the principle that such decisions should be made by Parliament. I haven't yet worked out whether this is meant to apply to Acts of Parliament whenever passed, even if passed long before Parliament would have addressed its mind to the appropriate balancing act. That's just another problem of this bill. It's only one troubling aspect of singling out only one of the Convention rights for specially advantageous treatment over all the others. There are problems about reconciling this expansive view of freedom of expression with other things that the government is trying to do. The Online Harms Bill, don't know how many of you tried to get to grips with that, is currently going through Parliament. It imposes duties upon user-to-user and search services having links with the UK in relation to 3 types of content: illegal content, content that is harmful to children, and content that is legal but harmful to adults. All service providers will have to undertake risk assessments in relation to illegal content and content harmful to children, and take steps to mitigate and manage the risks of harm to individuals and children. The largest online platforms will also have to conduct an assessment of the risks to adults from content which is legal but harmful, and set out in their terms of service what they intend to do about it. It is this which seems to have provoked the most alarm from free 3, which protects against torture and other inhuman or degrading treatment or punishment, and under Article 4, which protects against slavery or servitude and forced labour. The bill is quite clear. A positive obligation is an obligation to do any act. Clause 5 distinguishes between pre-commencement and post-commencement interpretations. A pre-commencement interpretation is one which has been authoritatively adopted either by a UK court or by the Strasbourg Court before the coming into force of the British Bill of Rights. This would include all of the above. A post-commencement interpretation is everything else. The bill is adamant that a court may not adopt a post-commencement interpretation of a convention right which would require a public authority to do any act. I foresee some lengthy battles about what is and is not an act for this purpose. But even with pre-commencement, including authoritatively established interpretations, the courts will have to decide whether or not to apply. In doing so, they will have to give great weight to the need to avoid applying, which would have an impact upon the ability of a public authority to perform its functions, undermine the public interest in allowing public authorities to decide how to allocate their resources, require the police to protect individuals involved in criminal activity or otherwise undermine their ability to decide their operational priorities, require an investigation to be conducted to a higher standard than is reasonable in all the circumstances, or affect the operation of primary legislation. The particularly troubling aspect of this provision is that it appears to be telling the trial courts that they do not have to apply the law as authoritatively laid down in the higher courts. They are allowed to consider whether or not to apply it. But the likely impact upon the protection of victims of crime is also troubling. The government's main target was the Osmond duty to warn individuals of threats to their lives, which the consultation paper says takes up a disproportionate amount of police time and resources, mainly for the benefit of wicked people involved in criminal gangs or serious crime whose lives are under threat. If the government wanted to stop that, it could easily have drafted the sort of targeted provision which has been adopted for deportation of foreign national criminals. Instead, it has adopted a blanket provision which could affect the protection of some much more deserving victims. A prime example, engaging Article 2, is the young mother who was murdered by her partner because the police failed to respond promptly to her emergency calls when they could and should have done so. Another example, engaging Article 3, are the women who fell victim to the black cab rapist, John Warboys. Multiple failings in the police investigation led to many more women being attacked than would otherwise have been the case. A third example, engaging Article 4, is the young man trafficked here from Pakistan to become the victim of modern slavery, whom the system failed to protect when it could and should have done. The bill will potentially deprive all these people of a vindication of their human rights. And these are the most fundamental, absolute and non-derogable rights in the Convention, not the more controversial qualified rights, in particular under Article 8. Most worrying of all to me was a recent piece on Radio 4's Women's Hour. A representative from Rights of Women complained of the effect, for example, on the Warboys case. A government minister gave a long account of everything the government was doing to improve the protection of women from sexual violence. All very welcome, but she did not explain how this justified the removal of remedies from women who have been failed by the system. Now is not the time to be reducing the protection which the law gives to the victims of all sorts of violence and abuse. There are other more specific provisions aimed at reducing the protection given to certain victims who are seen as undeserving. These include prisoners serving a custodial sentence, the definition of which is to be left to regulations, so it could, of course, be any custodial sentence. The court is to give the greatest possible weight to the importance of reducing the risk to the public which they pose in deciding whether a convention right has been breached, in particular in deciding whether he should be released from custody or placed in a particular part of a prison. It's obviously aimed at solitary confinement cases. They also include foreign national criminals, where the bill seems principally designed to insulate other laws from attacks on their compatibility with the Convention rights, specifically Article 8. There must be a separate plan to legislate for their removal, unless this will cause manifest harm to a member of their family that is so extreme as to override the otherwise paramount interest in removing them. And I do wonder whether this is intended to override cases such as ZH Tanzania, where the Supreme Court decided that the interests of the children prevented the removal of an illegal immigrant. The bill will also reduce the right to claim remedies in the UK courts. Claimants will in future have to obtain permission before bringing proceedings under the Bill of Rights. And the court can only give permission if the claimant is or would be a victim and has suffered or would suffer a significant disadvantage, although it can also give permission for reasons of wholly exceptional public interest. Significant disadvantage is expressly linked to the Strasbourg Court's criteria for declaring that an application is inadmissible because manifestly ill-founded. So it looks as if the claimant is not to be refused permission if Strasbourg would accept an application. But the UK courts will not find this an easy criterion to apply, especially if the interpretation of the Convention rights in the UK is uncoupled from Strasbourg's interpretation. How is that to work? However, it will mean that claimants exhaust their domestic remedies sooner than they would if their claims are allowed to go ahead here. So one can readily foresee that there will be more applications to Strasbourg and that more of them will succeed than would previously have done. Even if the claimant gets permission and a breach is found, the bill limits the remedies available. Damages can only be awarded if the claimant has suffered loss or damage. I think that this is designed to knock the idea of vindicatory damages on the head and limit claimants to compensation for the same sorts of loss and damage that they would get in an ordinary civil action. Yet vindicatory damages can be an important tool in encouraging public authorities to comply with fundamental rights. For example, if a person is deprived of his liberty in cynical breach of his fundamental rights when it might have been done lawfully but wasn't. Not only that, under the bill, damages can only be awarded if the court is unable to grant a remedy which would be just and appropriate without an award of damages. The court will have to consider the victim's own conduct, if relevant, whether or not related to the breach of convention rights. I'm not quite clear how it's relevant if it's not related to the breach of convention rights, but that's going to be another lovely case for the courts to decide. It's a clear hint, isn't it, that wicked people should not get damages for breach of their rights. And it will also have to consider the impact of an award on the ability of that or any other public authority to perform its functions, not only in this case, but in any future case involving the same or similar issues. Now, this is a consideration which does not apply to damages for the violation of ordinary rights by public authorities. Clinical negligence claims spring to mind. So why should it apply to the award of damages for violation of fundamental rights? And damages can't be more than Strasbourg would award, which is usually modest by comparison with compensatory awards here, but on the whole, that's a principle that we've accepted. The bill also alters the relationship between the UK and the Strasbourg court in other ways. You will now all know, if you didn't before, that Rule 39 of the Rules of Procedure of the Strasbourg court allows the court to indicate to the parties any interim measure which it considers should be adopted in the interests of the parties or of the proper conduct of the proceedings before it. The day before the first flight was due to leave for Rwanda, the court indicated that flights should not go ahead until the legality of the policy had been decided in the UK courts. The government complied. But Clause 24 does two things. First, a court is not to have regard to any interim measure in considering whether to grant relief which might affect the exercise of a convention right. And second, no account is to be taken of any interim measure for the purpose of determining the rights and obligations of a public authority or any other person under domestic law. On the face of it, this second provision is aimed not just at the courts, but at anyone, including the government. So it appears to mean that the government must ignore the interim measure in deciding what to do about the domestic position. It'll still have to decide what to do about the position in international law, but the Convention itself only requires the UK to abide by final judgments of the court. So I think that it's always been able not to comply with interim measures, but it has always done so. This opaque provision is no doubt a swift reaction to the Rwandan case, and we may get greater clarity in due course. Finally, how is all this going to work out in the very special environment which is Northern Ireland? I note that the bill is the Bill of Rights bill, and not, as hinted in the consultation paper, a British Bill of Rights. So that particular pitfall has been avoided. But it does represent a particularly British, nay English, form of anti-European nationalism, which may not play well with all the communities, either here or in other parts of the UK with devolved institutions. One question already being asked is whether the government will follow the Sewell Convention and seek the legislative consent of the Scots, the Welsh and the Northern Irish. But what is to be done while Northern Ireland does not have a functioning assembly? Will that be advanced as a reason for not consulting, not only Northern Ireland but also the Scots and the Welsh? Or will progress on the Bill of Rights be delayed until progress has been made on solving the Northern Ireland problem? Who knows? If enacted, the bill will apply throughout the United Kingdom. So the restrictions it imposes will cover human rights claims in Northern Ireland as well as in Great Britain. But another question is how it will affect the legislative competence of the Scottish Parliament, Welsh Senate and Northern Ireland Assembly. An act of the Assembly is not law if it is incompatible with any of the Convention rights. The Convention rights will be those defined in the Bill of Rights. But that definition in the bill simply lists the rights contained in the relevant articles of the Convention and protocols. So what if a Northern Ireland bill is incompatible with the Convention rights as interpreted and applied in Strasbourg, but not as interpreted and applied in the more restricted environment of the United Kingdom? Is it or isn't it law? Well, you're going to have fun with that one, aren't you, Chief Justice? Yeah. And what about the implications of the Bill of Rights for the Belfast Agreement? Well, the Chief Justice has already pointed out that the Belfast Agreement not only set up the human rights institutions here, but was premised on north and south of the border adopting equivalent human rights standards. That was the whole premise of it. Rights will water down the protection of human rights in Northern Ireland, thus potentially bringing about discrepancies between the level of human rights protection north and south of the border. The people of Northern Ireland will no longer be entitled to the same level of protection as the people of Ireland. How, for example, will the court's duty to avoid applying an interpretation of positive obligations that would require an inquiry or other investigation to be conducted to a standard that is higher than is reasonable in all the circumstances work out? Sounds reasonable enough, but why is it there, if not to water down the scope of inquiries into deaths for which the state may bear some responsibility? And this is irrespective of the fate of the Northern Ireland Troubles Legacy and Reconciliation Bill, about which I wish to say nothing at all. Yet this is the reverse of what the Belfast Agreement contemplated. It spoke of the new Northern Ireland Human Rights Commission advising on the scope for defining rights supplementary to those in the Convention to reflect the particular circumstances of Northern Ireland. As I understand it, this hasn't yet happened, but it is a clear indication of the direction of travel contemplated in the agreement. This is, I regret to say, another example of the UK government assuming the right to pick and choose which of its international obligations it will comply with. As Adam Wagner said in a letter to the Times, the Bill of Rights Bill is nothing to do with common sense. Shamefully, it is the first Bill of Rights to weaken, not strengthen, rights protections. Thank you.
We're just going to take questions.
Thank you very much, Lady Hale, for an absolutely fabulous talk. And I have to say, as a non-legal person, you have a gift in bringing law to life and making sense of it. And I love the way you put such a spotlight on the driver's intent and implications of the areas you touch on, because that really does bring it home. So thank you very, very much for that. It was absolutely brilliant. We have time for some questions, and I'm going to take questions from the floor here. We're also going to try to get online ones on. We'll do our best to get this, so people be a little forgiving for us if we don't manage this too well. From those on the floor, if you can put your hand up, we have a little roving mic, and give time to get the microphone down, and we'll take the questions from that. I've just got one personal request to you. You know, questions are questions, orations are orations, so if you can keep the questions nice and tight and punchy, so we can get an answer from our guests. Who'd like to go first? Go ahead. We've got 1 and 2. Good evening.
I was just going to ask a question to break the ice more than anything. My name's Kalia Suma, and I'm the Commissioner for Children and Young People. I suppose, thank you very much to Lady Chief Justice and of course to you, Lady Hale. You ended on a very bleak note, and I suppose my question is, do you think the British Bill of Rights and the legislation makes a Northern Ireland Bill of Rights more or less likely? Let's assume we could agree what the content of that would be here. Let's live in cloud cuckoo land. But do you think that it makes it more or less likely?
I don't think. Sorry, is this on? Yes. Yeah. I don't think it's. I'm qualified to say whether it makes it more or less likely. I think it must be obvious from everything that I said that it would make it more necessary, simply to restore the position as it is at the moment, let alone to add additional rights to meet the Northern Ireland situation. I did raise the question as to what the competence of the Assembly would be, because there's definitely an argument that would say that it would be within the competence of the Assembly to pass legislation that was compatible with the rights as defined in Strasbourg, rather than with the rights as defined under the new Bill of Rights. There's certainly an argument to that effect, which one would imagine would take 10 years to reach the Supreme Court. This is on the assumption that a bill stays as it is, and of course, who knows what's going to happen. So I don't know about likely, but necessary, yes.
A question? Down here.
Just a quick kind of structural question with regard to common law. Does this codification of the Bill of Rights imply some kind of weakness within the common law system, or is it not at all possible to produce evolutionary a kind of Bill of Rights more organically through that way and through the courts, but more diplomatically or peacefully, rather than this very politicised Bill of Rights? Thank you.
The common lawyers have always been very proud of their ability to protect fundamental rights. But of course, the one thing they could never do is protect fundamental rights against the assaults of Parliament. And the Human Rights Act was there to do two things, one of which was to translate the Convention rights into rights in UK law. So that meant that the UK courts were talking the same language as the Strasbourg European Court of Human Rights is doing, which is not the same language as the common law, but a very constructive language, which is why we have lost so few cases in Strasbourg since the Human Rights Act, comparatively. But of course, it was also there to give a nudge to Parliament not to interfere with the Convention rights. And by and large, Parliament has not done so. I mean, Parliament's record in responding to declarations of incompatibility has been exemplary. There's only one real exception, and that's prisoners voting, which they dragged their feet on for so long that eventually Strasbourg accepted that some very minor administrative changes was enough, and the problem went away. But basically, they have implemented all the declarations of incompatibility. And so, by and large, a common law system has kept pace with the Strasbourg system in a very constructive way since the Human Rights Act. Well, I say the purpose of this particular bill appears to be to uncouple the two. And I am totally puzzled, as I said, by what on earth is the point of a provision saying that we can have regard to the development of a convention right, or a right similar to a convention right under the common law, if we're not allowed to take the convention rights further than Strasbourg has done. I mean, I can't see what that's for at all, apart from window dressing, which an awful lot of the bill is. So I don't know if that's an answer to your question, but I've tried my best.
Thank you very much, Lady Chief Justice and Lady Hale. I had a question about the repetition in the bill of the words great weight and greatest weight and so on and so forth. And I wonder if you might talk about the kind of, because I think it aims towards sort of rebalancing, possibly rebalancing the sort of interpretational exercise done by the courts. But I wonder, does it just create more confusion than anything else? And I say this because I was at a different conference a couple of days ago where public lawyers were raising the same question, that we don't know what this means and how this can be applied, never mind how it should be applied.
It's interesting, this rebalancing thing, isn't it? Because it does appear to be putting a lot of weight on one side of the scales and taking weight away from the other side of the scales. That seems to be the object of the exercise. It's not going to be easy for the courts to apply any of those provisions in the particular contexts in which they've been put in there. On the whole, I think provisions like that are not helpful. I mean, the courts know they've got to do a balancing act. They know that the convention rights, particularly in the qualified convention rights are all about fair balance between the interests of the whole community and the interests of the individual. It's not easy to strike that, but it's not helped by saying you give greater weight to one side of that equation than you give to the other side of the equation. So I don't think it's helpful from a judging point of view, but there we go. I would say that, wouldn't I? Is there anything you want to add?
Yeah, I think I think, Anurag, you raise a good point in relation to, particularly as Lady Hale says, the qualified rights that the judges have to balance day in, day out. I mean, I think of Article 8. I also think of some of the difficulties with Article 10, Article 10.2, and the need to justify and reason. I mean, what you could be looking at here is potentially long lines of litigation on these issues, various appellate stages. It coincides, I think, with Kuala's question, which is there will be a question potentially in relation to the application of Section 6 and what that actually means vis-a-vis the legislative competence of the Assembly. So there could be uncertainty in relation to these issues. It's quite hard. We have created some standards through jurisprudence that are headlines in these various areas that we may have difficulty coming back to. These are difficult judicial exercises anyway. There are pitfalls with further definition on that you've outlined.
Yeah, we just have an online question here. Do you feel the impact of this government's policies and public pronouncements on the courts and lawyers, example inverted commas, activist lawyers, enemies of the people, is having an impact on how courts are deciding cases?
Well, I can't really see a correlation, actually. Safe to say, I think plenty of people have commented on this issue, which comes back to the independence of lawyers in taking cases and the independence of the judiciary. So I don't think there's a correlation myself.
I very much hope there isn't a correlation, but there's an all-party parliamentary group on the Constitution, not the Constitution Committee, but an all-party parliamentary group, which has very recently published a report which details some of the attacks on the judiciary from the media, which is one thing. I mean, the media are the media, and from government ministers. Then it goes through some of the recent Supreme Court cases which have appeared to be curtailing or rowing back on some of the earlier cases under the Human Rights Act. And this report draws a correlation between those two phenomena. I better not do anything more than draw your attention to that document.
Thank you very much, Lady Hale, for a terrific talk. I'm wondering, in your capacity as a member of the House of Lords, you anticipate saying there some of the things that you've said here today when this bill goes to the House of Lords? And do you anticipate your colleagues in Lords who are retired judges adopting much the same line as yourself?
Well, thank you for the question. I've got a horrible confession to make, that I haven't yet played any part in the parliamentary business of the House of Lords since I became entitled so to do in January 2020. And a lot of that has had to do with the COVID restrictions on participation. And some of it's had to do with not having had enough time to familiarise myself with the atmosphere in the House of Lords. I'm fairly sure that the House will take kindly to a lecture such that I have just delivered, in bite-sized pieces, you know, attacking each particular thing. We'll have to wait and see. I very much hope and believe that there are lawyers in the House of Lords who will mount an attack on various aspects of this bill, including, one hopes, the root and branch attack on the necessity for it at all. And I hope that I may have got myself round to doing something about it in due course. Meanwhile, I'm not going to stop saying the sorts of things that I have said here, which may just possibly trickle through to a few other people. So, thanks for the question.
Given the preeminence of European Convention rights within both the Belfast Good Friday Agreement and EU law in general, are we likely to see a clash between this proposed Bill of Rights and Article 2 of the Northern Ireland Protocol?
I'm not qualified to talk about the Northern Ireland Protocol, simply not qualified to talk about it. I have already drawn attention to what I see as a clash with the Belfast Agreement. I think that's fairly clear. So what will happen as a result? Who can say?
Just after your speech there, I was thinking that potentially if you were to put a positive spin on it, obviously they're trying to grapple back power in a way to for the UK itself to litigate. I was thinking potentially that could provide for future better protections, but then thinking about what's happening at the minute in England with all the criminal barristers on strike and these bills being pushed through Assembly without proper scrutiny, I was just wondering what your opinion on that is in terms of human rights and who's going to eventually challenge it.
Your point is about access to justice, really, I think, because what you're saying is that lawyers are on strike in the criminal bar are on strike in England and Wales. Is that right?
Yeah, well, in terms of the immigration and asylum
Yeah.
seekers and things like
Yeah.
that, especially
Yeah.
with that access to justice issue combined with this Bill of Rights
Yeah.
and the barristers, I would just like your opinion on it and what you see happening.
I think they're two different things. I think you've got you can discuss the Bill of Rights and what that means, but you also have running alongside that the need for access to justice for the different sections of society that I talked about that need to bring cases to court for vindication of rights across different realms, and that's why you need a vibrant, independent legal profession that is properly set up, and I think in Northern Ireland we are proud of that. If there are difficulties in other jurisdictions, they need to be grappled with, and as I understand they are being grappled with. But it's part and parcel. Actually, I was speaking to new barristers and solicitors this week about their future, and part of the rule of law that I talk about quite a lot with new recruits to the profession is actually being independent and bringing cases for people to courts. There's no point, in a sense, in people having rights if they can't actually have them dealt with in a legal forum. So I do think they're two different issues, but are interconnected. If that answers your question to some extent, Brendan.
Well, you're right to raise the question, obviously. You know, there's no point in our bothering about all of this if people can't get to court, you know, to have all of these issues litigated. I think we've got to say two things, one of which is that, and therefore there must be access to justice for people to be able to litigate these things. But I also think that the profession, certainly in England and Wales, and I would imagine also here in Northern Ireland and indeed in Scotland, is sufficiently determined about its role in protecting individual rights to find ways of bringing these cases. I'm quite optimistic about the capacity of the profession to meet the challenge and challenges which undoubtedly are coming its way under this proposed piece of legislation. So,
Thank you very much for the excellent presentation. My question is about lawyers who are engaged in processes before these pieces of legislation are passed, in terms of responding to consultations, doing lots of research, putting lots of energy, time into engaging in the processes, but effectively to be either ignored or not given proper access to those consultations. So I wonder if you have any words of advice for organisations who are engaging as to how they should go about do that in the most effective way possible.
I think it would be presumptuous of me to offer any words of advice. We've had 2 examples recently where the government set up an independent review of administrative law, which did quite a comprehensive job and decided there was nothing much wrong with administrative law, made a couple of relatively minor recommendations. And then the government decided it was going to consult on something much bigger and broader. But on that example, they drew back because the response to consult was, this is not a good idea. Whereas with this one, they again set up an independent review, which did an awful lot of work, produced a massive report, and then the government said, well, thank you very much, but we're going to do something completely different, which they then consulted on. And I said, I haven't yet read the government's account of the response to consultation. I almost believe I can't bear to, because I am aware of sometimes how accounts of responses to consultation are constructed. But I suppose one of those stories suggests that, yes, it is worthwhile responding to consultation, and the other one suggests, no, it isn't worthwhile responding to consultation. So I'm afraid the answer is yes, you've got to. Because otherwise, it'll be said that you didn't care, you know, that nobody was bothered enough about it to do anything about it. So thankless though the task is, and very time-consuming, and it takes a lot of trouble, I think you've got to do it.
Thank you. Time has caught up with us. So we'll draw things to a close now. And first of all, I'd like to thank everybody attended here, everybody who has watched online as well. Thank you. So we do appreciate you giving your time to be with us and stick with us too. Special thank you to our Lady Chief Justice for her opening address, and to Lady Hale for what is a powerful speech here today. So thank you very much for both of you.